Good afternoon and welcome to Keating's 5th Public Procurement Surgery, green-listed for all questions concerning public procurement. I'm David Gollancz, and your panel of practitioners consists of Sarah Hannaford, Fionnuala McCredie, Charlie Banner and Simon Taylor. As usual, we will start with a presentation by each of our panel, followed by an opportunity for you to submit questions on the topic. If you want to ask a question, please do so via the Q&A button, which you will find at the bottom of your screen. And you can do so anonymously if you wish, or identify yourself. My apologies in advance to anybody who asks a question and is not answered. We're going to stick fairly rigidly to time, so I may be a bit selective. Before we start, please remember the Chatham House rule. You're welcome to quote anything you hear this afternoon, but please don't attribute it to any individual or organization. And so to the subjects of our 3 talks, or 4 actually, 3 topics. Simon is going to kick off by considering the place of social value in procurements. And this arises from a question we were asked at the last surgery, but hadn't the time to answer. Sarah and Charlie are going to talk about different aspects of the PPE litigation. That's not litigation about politics, philosophy and economics, but about personal protective equipment brought by the Good Law Project and Every Doctor. Allow me briefly to plug Charlie's and my podcast about the question of the Good Law Project's standing considered by Mr. Justice Chamberlain, which will soon be available on our website and from the usual podcast providers. Fionnuala will be talking about the issues arising from the participation in procurement litigation of interested parties. So as I say, if you have questions, do please post them in the Q&A box. They're very much encouraged. And with that, I think Charlie and Fionnuala and Sarah are going to modestly tiptoe away from the screen while Simon starts to tell us about social value. Simon.
Thank you, David. Good afternoon, everybody. So I was asked a question about the new PPN 0620, which kicks in from the 1st of January 2021 on social value. And I was asked really generally to give thoughts on it and then some specific questions that I'll come back to. So in terms of overall thoughts, what is it? What is the social value PPN? Well, it is an instruction to evaluate social value in all central government procurement, which is above threshold and is subject to the public contract regulations. It's mandated on government bodies, on non-departmental public bodies and on executive agencies from the 1st of January 2021. There is an older set of guidance called Balanced Scorecard in relation to procurements for construction, capital investment, infrastructure projects over 10 million. But this is more formal and is more onerous, effectively, more directive. The rule is that there is to be a minimum weighting of 10% of the total score attributed to social value, to the assessment of social value. And the only exception to that is where market engagement by the procuring body indicates that this would significantly reduce competition due to the lack of maturity in developing social value in the market in question covered by the procurement. And in those circumstances, then it has to be 10% of the quality score. So it can also be higher than 10% of the overall score if the market is mature in relation to the development of social value considerations. There is a model on social value, and there's detailed guidance. What it does is it sets out certain themes, such as tackling economic inequality, COVID-19 recovery, equal opportunity in fighting climate change. And then there are policy outcomes, such as, for example, job creation, new skills, apprenticeships, etc. This is to be a golden thread throughout every stage of procurement. So it starts with the awareness building in the government department through to the planning of a procurement, market assessment, engagement with the market, drafting the specification and tender documents, evaluation of the bids, managing the contract, and then ultimately reporting. And this is called the social value golden thread. There are model award criteria in relation to social value, and also metrics for incorporation into the contract and reporting. And users are to ensure that the criteria that are applied are related to the subject matter of the contract, because that's a requirement of the regulations, and are also proportionate to the contract and comply with equal treatment and transparency. But that isn't a get out of the basic obligation, which is to comply with the 10% rule. So is it lawful? Yeah, yes, it is. It's quite consistent with the public contract regulation. So if you look at regulation 67.2, since the 2014 directive, you've been able to include social criteria as part of your award criteria, provided that they're linked to the subject matter of the contract. And that, if you recall, codified some of the case law, such as Commission v. Netherlands, that led up to the directive. The directive also, in regulation 67.5, defines linked to the subject matter of the contract very broadly. And I won't bore you with the detail of that, but have a look at it. It leaves a lot of scope for the use of social value considerations. So that is what it is broadly. What is it not? Well, it looks like something that a Labour government would introduce rather than a Conservative government, but it isn't the Communist Manifesto. It isn't the abandonment of commercial market-based procurement. In fact, the PPN specifically says that the overarching objective of government's commercial activities will remain best commercial outcome. So this is quite a mixed message. I mean, if it had said the overarching objective will be going forward 90% best commercial outcome, 10% social value, then that would you'd sort of understand that and that would work. But it didn't say that. The overarching objective is best commercial outcome. So the point is here that increasing social value in procurement is, of course, likely or potentially will have a broad societal long-term benefit and can also remove the need for costs in other parts of government, such as social welfare, environmental, other costs, etc. But if bidders are required in procurement as a result of the award criteria to do things like create jobs or training opportunities or cutting environmental impact that they would not choose to do commercially, then that may have a cost which will then be factored into the bid price. So the commercial outcome in the narrow sense of the procurement may well be the government pays more, and that of course would be inconsistent with the overarching objective which is articulated in the PPN. So possibly it means that social value which comes at a cost will be discouraged. It's unclear how this will work in practice. And of course, some of the social value themes that are set out in the guidance will cost more than others. So for example, one of the themes is supporting the health and well-being of the workforce. Now that should make commercial sense to any tenderer and is unlikely, it shouldn't have a cost. But whereas others, such as creating jobs and training for those worst affected by the COVID crisis, may well have a cost. And there's flexibility within government departments and procuring body as to which themes you choose. And that may well drive the way in which this works in practice. It's also unclear what the Cabinet Office is going to do to enforce this. That there's reference to spot checks and enforcement through the spending control process. The other thing that it is not protectionism. It's not a requirement to support local jobs, and that, of course, would infringe the international treaties, the TCA, and also the GPA. So government departments will need to be careful in the way in which it is implemented, although there may be ancillary benefits in terms of local job creation. So the specific questions, that's the overview. The specific questions I was asked, there were three questions. One is, give us a steer on the type of contracts which will not be relevant to this obligation and where it won't be proportionate to apply the social value model. Well, I think the answer to that is that it literally applies to all contracts. the government departments just have to apply the model and make the choices among the themes in a proportionate way, and which is contract related. But there isn't any exception to the 10% rule other than the one I mentioned, where it goes down to 10% of the quality weighting. There is a footnote in the guidance which indicates that a government department needs to document why it isn't applying social value criteria. But it's not obvious what any justification there would be on the basis of the PPN and the basic rule that there has to be a 10% weighting. So this is something for every above threshold contract under the PCRs, not under the utility contract regs or the concession contract regs. The other question I was asked is, do you need to use the whole of the 10% allocated to social value? And the answer is yes. It's a 10% rule which has to be followed. And then lastly, the other thing I was asked is the social value element tends to be linked to the tender, to the subject matter of the contract. Do you agree? Yes, I agree, as I've said. Is there any scope to use the social value model as part of the selection stage rather than the award stage? And I think the answer there is there's nothing to stop you using social value considerations at selection stage. In terms of eligibility, that many of the eligibility criteria relate to social value, but even in shortlisting, there's nothing in theory in a restricted procedure to stop you shortlisting on the basis of things like social value. But that doesn't let you off the basic requirement to apply the 10% rule at the award criteria stage. So it isn't a let out from the basic obligation. So that's all I had to say, David, and very, very happy to take questions. But it's a brave new world, and obviously one which is going to be very interesting.
Thank you, Simon. I mean, I think the question that looms over all of this in a way is, what is social value, isn't it? How free do you think contracting authorities are to define it in a way that suits them? And is that anything which could be subject to challenge, for example, by actual or potential tenderers?
It's difficult to see how any of this is enforceable by a potential tenderer. I mean, if a government department fails to follow the diktat in the PPN, it's difficult to see how that gives rise to a legally enforceable right under regulations, because this rule isn't in the regulations. So I think it's an internal government policy rather than an enforceable rule. And I think it's quite a flexible policy, because when you look at the themes, they're very broad, and some of them are very, very clear social value, like job creation for, it doesn't talk about long-term unemployed, but it talks about those who are unemployed as a result of COVID recovery. Sure. And others are more, things like the Equality Act, where you have to do that anyway. So there are a lot of things there that you have to do anyway, but you can build it into the criteria to check that the tenderers are, that they are doing it. So sure. I think it's flexibility.
Sean Jameson asks, I'll slightly reframe this. He refers to the restrictions on local authorities taking into account non-commercial considerations, and says, to the extent that that still exists, how would the PPN impact it? I think that the legislation he's thinking of is the exclusion of non-commercial considerations imposed by, I think, if our memory serves, section 17, or it might be 19 of one of the innumerable local government acts, and the modifying order made under the Blair administration, which somewhat drew the teeth of that restriction, but didn't completely remove it, certainly as regards, I think, services contracts. So presumably the PPN, you say, it's addressed to central government, is that right?
Yeah, it doesn't apply to local authorities, but local authorities have been in the forefront of driving social value, as well as the devolved administrations in Scotland and Wales. So they're used to social value very often. And I think that rule in local government legislation, I mean, arguably it's been superseded by the EU directive, which expressly talks about social value as an award criteria. But yes. In any event, I'm not. I think it's honoured more in the breach than in the compliance, isn't it? But yeah, the PBN doesn't apply to local authorities anyway.
Right, so they're just governed by whatever legislation does govern them, and there may, you think, be some tension, let's say, between the directive and for as long as that's still relevant and domestic legislation.
Yeah, I think there always has been, isn't there?
Right, thank you. I hope that satisfies Mr. Jameson and his acute question. Thank you, Simon. We're as always, we're under a bit of pressure of time, so rather than further exploring the very interesting topic, I'm going to invite Sarah now to talk about one aspect, at least, of the PPE litigation brought by the Good Law Project over a number of claims. Sarah.
Thanks very much. I'm sure you, like we, have followed the Good Law Project's challenges in recent months to pandemic procurements, particularly in relation to PPE. Almost daily tweets emerge. For example, today, I saw the tweet, the final day of our High Court hearing over huge PPE contracts to firms with no prior experience, and the VIP lane is underway. All exciting stuff. So Charlie and I are going to pick up on some of the key points from those cases, which apply not just to pandemic procurements, but I think with these points to all procurements. And I'm going to start with what used to be some little known requirements of the transparency policy and the transparency principles, which were picked up on in the Good Law Project's claim against the Secretary of State for Health and Social Care earlier this year. Two reported decisions. One is EWHC 346 and the other is 505. I give you the numbers because there are so many Good Law Project cases that you might not otherwise find them. The second judgment follows on from the first in that case, and that was necessary because at the time of the first judgment, the government hadn't yet worked out how many contracts it was in breach of the relevant requirements in relation to. So the second judgment deals with the number of contracts in relation to which it was in breach. Although even by the time of the second judgment, the government hadn't in fact worked out in all cases how many breaches there were. Anyway, with that background, there were three key allegations of a breach of transparency in this case. Firstly, failure to publish a contract award notice in accordance with Regulation 50 within 30 days after the award of the contract. Secondly, failure to publish information on Contracts Finder within a reasonable time under Regulation 108. And thirdly, as I said a minute ago, failure to comply with some little known guidance in 2017 called, first of all, Publication of Central Government Tenders and Contracts, Central Government Transparency Guidance Note, a snappy title, which the judge called the Transparency Policy, and then PPN 01 of 2017, which is called Update to Transparency Principles, which updates a 2015 document, with the attached document called the Transparency of Suppliers and Government to the Public, and the judge called that the Transparency Principles. So what does the judgment tell us about these important areas of transparency? The first breach I talked about, what I mentioned a minute ago, was contract award notices, so Regulation 50. Regulation 50, in my experience, possibly not in yours, is more honoured in the breach, but what it requires is publication of a contract award notice not later than 30 days after the award of the contract. As the judge found in the Good Law Project case, there's no room for non-compliance here. It's a mandatory legal obligation in the regulations, but there are 2 points to note. Firstly, as happens in other areas of the regulations, information can be withheld. That's under Regulation 50, subpart 6, for things like where it would impede law enforcement, would be contrary to public interest, would prejudice the legitimate commercial interests of a tenderer, or might prejudice fair competition. So there are some grounds for withholding information. The second point, I think, which is of interest, is what is meant by not later than 30 days after the award of the contract. Does that mean after the contract award decision, or when the contract is actually signed? It can't realistically surely mean 30 days after the contract award decision is made, for example, by counting from the standstill notice, because in complex contracts, you'll never actually get to a contract within 30 days of the standstill notice, and nor, of course, will that happen if there is a legal challenge. So in this particular bit of litigation, the parties were in dispute about whether it meant 30 days from the award decision or 30 days from signing the contract. But the judge didn't actually decide that point, because it appears from the judgment on either view, the Secretary of State was in breach. So he proceeded on the Secretary of State's view, which was 30 days from the signing of the contract. What the judge did make very clear in relation to Regulation 50 was that there being a pandemic was no excuse for not complying with it. So that was the first breach. The second alleged breach was failure to comply with Regulation 108. That's the regulation that says that you must provide information about the contract awarded where either a contract award notice is published or a call-off contract is awarded, and you don't need to publish a contract award notice. And you have to provide information like the name of the contractor, the date on which the contract was entered into, and the value of the contract. And again, there are some exceptions from publication, as there were in Regulation 50. And the publication obligation in the regulations is within a reasonable time. That's what Regulation 108.4 says. And in accordance with Regulation 108, and just in this specific instance, the regulations say that authorities have to have regard to Cabinet Office guidance on the form and manner of the publication, and also what is a reasonable time. So duly there was some guidance, which is called Guidance on the New Transparency Requirements for Publishing on Contracts Finder, and that tells us what a reasonable time is considered to be. And the guidance recommends that the information is published no later than 90 days after the contract award date. So the claimant in the PPE case claimed that there'd been a breach of Regulation 108.2, but the judge didn't allow them permission to run this ground because they needed to amend, and he didn't give them permission to amend. The reason for that is somewhat confusing, in my view. Slightly bizarrely, the judge decided they shouldn't have permission to amend because the regulation itself didn't give a deadline. It said a reasonable time. The deadline was in the guidance. The Secretary of State didn't admit there was a legal obligation to comply with the recommendation and the guidance, and the Secretary of State hadn't admitted breach. An interesting set of reasons, I think, for refusing permission to appeal, but particularly when you get on to what the judge found about the binding nature of the guidance in relation to the third alleged breach. So the third alleged breach is the one about compliance with the transparency policy and the transparency principles. Now, where we've got to so far is 2 time limits. For the publication of contract award notice, it's 30 days from, and we had a discussion about from what, and for the publication of the information under Regulation 108, it's 90 days according to the guidance. But now, and you may think somewhat oddly, the Crown Commercial Service guidance, the transparency policy, gives a shorter deadline, apparently for publication of the contract itself. And that's at paragraph 9 of the transparency policy. What it says is that following any permitted redactions, as set out in this guidance, it's advised that contracts are published with the award notice within 20 days. There's then a footnote to the guidance that I talked about a minute ago, which says that information about the contract award should be published within 90 days. And don't forget, of course, that the contract award notice is due to be published within 30 days, not 20 days. So this is quite odd. Anyway, it says within 20 days following the end of the standstill period, where applicable. Where the standstill period applies, the contract shouldn't be published before the end of the standstill period. And where it doesn't apply, it's advised that departments publish contracts within 20 days from the award of the contract. That's paragraph 9.1. And paragraph 9.2 says, if a legal challenge to a procurement arises or is current during the standstill period, the contract should not be signed until any outstanding legal dispute is resolved. It then puts a full stop and doesn't say what that means in terms of when you should publish your contract. Anyway, so we apparently have an earlier deadline of 20 days for the most contentious and difficult thing to disclose. That's the contract itself. 20 days from the end of the standstill period. And as I said a minute ago, there'll rarely be a signed contract by then. And maybe paragraph 9.2, the one that ends with a full stop but no explanation, is supposed to indicate that your 20 days runs from the date of contract signature. So that's what the transparency policy says. What do you need to publish? Because it did say at the beginning of 9.1, subject to any redactions, you have to publish as a minimum, it says the specification, the terms and conditions, and the associated schedules, which it says may include the winning tenderer's bid. So this is pretty feisty stuff. Can you redact it? Yes, says paragraph 7. You can redact it in line with FOIA and what was said in the other guidance, the transparency principles. And that means that the following categories of information can, if appropriate, be withheld on the grounds of commercial confidentiality. And that'll be, there's 3 things. Pricing, so that's not the price, but the way the supplier has arrived at the price. Intellectual property, certain proprietary details of the solution could be confidential. And thirdly, business plans, detail of how the contractor expects to yield a financial return, including investment plans, could normally be withheld. So that's what it is. As I say, it's quite feisty. Maybe that's not the right word, but it's certainly challenging to comply with. But of course, it's only guidance. And not many people had heard of it before this case, including the man in charge of the procurement in the case, as Charlie said a moment ago. So can it really apply? Well, that was the $1 million question in the case. And the judge decided that the Secretary of State was obliged to comply with it, absent good reason from departing from it. And he quoted well-known law saying that contracting authorities are obliged to act consistently with published policy. There wasn't any real analysis of the case law as to whether this was a bit of public of guidance which a public body was obliged to comply with. But what he said was, for 3 reasons, this guidance was binding absent good reason. And his 3 reasons for reaching that conclusion were, first of all, it didn't matter that it wasn't mandatory, it was just hortatory, because policy can always be departed from for good reason, so it doesn't matter how it's expressed. Secondly, some policies leave a measure of discretion or leeway, and whether there is one is a matter of construction for the court. Thirdly, the 20-day limit here was framed in precise terms and was an important element of the government's transparency commitments, and the aim of committing to transparency would be significantly undermined if the time limit were understood as imposing no legal constraint at all on government. And here, so it applied unless there was a good reason. There wasn't a good reason because no good reason had been applied by the Secretary of State. The reason it hadn't been applied, this policy hadn't been disapplied for good reason, of course, was because the relevant witness had never heard of the guidance, which he candidly admitted. So the Secretary of State's conduct was unlawful. The Good Law Project was entitled to a declaration to that effect, but not a mandatory order that the Secretary of State should do anything, because the government by the time of trial had almost complied with its obligations. Almost, but not quite, and they were still counting how many they were in breach in relation to. So is this case just all a lot of fuss about not very much? The Good Law Project got a declaration, no mandatory relief. And whether you think it's a fuss about not very much depends on what the aim really is. If the aim was to expose how important transparency is and how it hasn't happened in the pandemic in some situations, then that was done admirably. If the aim was to get wider remedies, then the challenge was unsuccessful. But one other thing I think is worth noting from the judgment, there's a very interesting bit at the end of the judgment where the judge allocates blame between the Good Law Project and the Secretary of State for ending up at trial. On the one hand, he said the Good Law Project consistently put its case higher than was warranted. He said it reached for pejorative qualifiers, such as that the breaches were egregious and widespread, and he didn't think that helped. On the other hand, however, the government simply refused properly to admit breach, he said. The government said things like there were technical breaches and there were regrettable delays in publication, but he said there was no proper admission of breach until the skeleton argument. The judge didn't think much of someone qualifying an admission of breach by the word technical. He said that was in an apparent attempt to say that the breaches were trivial or had occurred in an insubstantial number of cases. In his view, a breach was a breach and should be admitted at an early stage. So where does all that very complicated transparency stuff get us and that decision? I think there are three key takeaway points. One, read obscure guidance in case you have to comply with it. Two, call a breach, not something else that doesn't sound quite as bad in your pleadings. And three, call a breach early on if you've breached it.
Sarah, thank you. Very cogent and to the point. I think, I mean no disparagement of the Good Law Project at all when I say that there was an element, wasn't there, of performance on both sides. In a sense, this litigation is being very much it's politics being done in public on another stage, and no doubt that has had some impact on the use of language like egregious and technical, and not likely to please the judges, I guess. But thank you. That was extremely helpful. Charlie, are you with us? Yes, he is.
I'm indeed. Hi, David.
Not quite as smartly dressed as you are in your profile picture, but
yes, sorry for having that looming over you.
Smart enough for Zoom.
Thank you, David.
Charlie, take it away.
Thank you. Well, I'm going to pick up really where Sarah left off on the GLP litigation, but focus on three public law aspects. And the first thing I'm going to dwell on is the issue of standing for judicial review in procurement cases. And the key question here that keeps coming back again and again through the case law is, in what circumstances can someone who isn't an economic operator and therefore isn't owed the tortious duty under the regs and not entitled to the remedies prescribed by the regulations, in what circumstances can they bring a claim for judicial review of the award of a public contract on the ground that there's been a breach of the regulations? And in the Wild case in 2017, Mr. Justice Dove answered that question in very narrow terms, which meant that the pool of potential JR claimants in procurement was pretty limited. And the recent Good Law Project litigation has taken a notably wider approach, which may mean that procurement judicial reviews become more common, and not just by the Good Law Project itself, which has generated several of them in the last few months. The background to this issue starts in Chandler, where the Court of Appeal indicated, albeit briefly in obiter, that there were two potential situations where someone could bring a JR on procurement grounds. Limb 1, where despite not being an operator themselves, the claimant had a sufficient interest in compliance with the public procurement regime, in the sense they're affected in some identifiable way by the challenge decision. And an example was given where the compliance with the procurement regime might have led to a different outcome that would have had a direct impact on the claimant. That's limb 1. And limb 2 was where the gravity of the departure from public law obligations justifies the grant of public law remedy. My example of a paradigm would be a flagrant abuse of power, such as an actual bias. It should be said the Court of Appeal in all the cases, including Good Law Project, proceed on the basis that the regulations generate public law obligations in the first place, as opposed to conferring private law rights. Not a question has actually been definitively answered by the courts on appeal. Now, the first of the subsequent cases concerned the position of trade unions, representative bodies such as Unison and the Law Society, and then evolved into the more controversial issue of whether a local resident who objected to a development in their area on essentially planning grounds was standing to challenge the award or variation of a public works contract relating to that development. In a case called Gottlieb, Mr. Justice Lang held that such a person did have standing, but then in 2017, in Wild, Mr. Justice Dove declined to follow Gottlieb on the basis it was plainly wrong. In a judgment which reviewed all the case law on standing, he held that the claimants who were local objectors to development didn't have standing to challenge the variation of the works contract for the development. He noted the statutory test for standing in JR is a sufficient interest in the matter to which the claim relates. And he held that in procurement, the matter to which the claim relates is ordinarily the award of a contract, and that a sufficient interest in that context meant being directly impacted by that award. The claimants weren't, he said, remotely approximate to any economic operator, nor could they begin to demonstrate any interest in the procurement process, which might be akin to or proxy for status as an economic operator. And I generally took from this, as I think most people did, that there needed to be some kind of representative or derivative interest in the claimant. So they would be an intended subcontractor, a major shareholder, a JV partner, a representative body, or something like that to have standing. And perhaps it was no surprise that it then went pretty quiet on the procurement JR front for a while after Wild, until the Good Law Project litigation. And the first of the recent Good Law Project litigation claims results in a judgment by Mr. Justice Chamberlain, which is the one that Sarah was talking about a moment ago in February. And that didn't concern an individual procurement decision, but rather the Secretary of State's general approach, as you've heard, in relation to timing of award notices and publication of contracts. And the Secretary of State relied on Wild in submitting that the Good Law Project didn't have standing. And Mr. Justice Chamberlain didn't agree. He said they did have standing. He said that Mr. Justice Dove's approach in Wild had gone too far, as it negated limb 2 of Chandler, the sufficient gravity limb. And in any event, he said that it didn't, that particular case Wild didn't apply, as Good Law Project weren't challenging a specific contract award, but rather a general approach, and there was a broader interest in that general approach. So we're now in a situation where we've got obiter from the Court of Appeal, the application of which by Mrs. Justice Lang in Gottlieb was later held to be plainly wrong by Mr. Justice Dove in Wild, who was then later held to be wrong by Mr. Justice Chamberlain in Good Law Project. It's surely calling out for a definitive judgment of the Court of Appeal. But in the meantime, it seems that Wild now, and not Gottlieb, is the odd one out. I feel a little bit responsible for this because I acted as the successful contractor in Wild, and the parts of the judgment which are held to be plainly wrong by Mr. Justice Chamberlain were effectively adopting my submissions. But I suppose I'll take consolation that I was at least persuasive, if not right. The liberalisation of the approach to standing in procurement cases following Good Law Project means that JR practice and procedures become more relevant for procurement lawyers. And this is the subject of the two issues I'm quickly going to cover relating to the other Good Law Project cases. So the second issue concerns cost capping, and this tends to arise in JR proceedings where a non-commercial claimant, such as a charity, NGO, or a member of the public with shallow pockets, brings a claim, and they say the prospective liability to pay the defendant's costs if they lose would deter them from continuing with the claim unless the costs are capped in advance, previously called a protective costs order, PCO, now a cost capping order, CCO. Prior to 2015, the courts had fashioned principles for PCOs, the lead case being something called Corner House. That was later refined and put on a statutory footing by the Criminal Justice and Courts Act, Section 88, expressed to be available for JR only, so only available for procurement JRs. The statutory criteria include that an issue in the proceedings is of general public importance, and that the public interest requires that issue to be resolved, and that the proceedings are an appropriate means of resolving it, as well as, of course, that the claimant would be deterred from bringing the claim without a cost-capping order. And this issue arose in the context of one of the Good Law Project claims this year relating to the direct award, relying on Regulation 32(2)(c) of a contract for the provision of online and telephone polling services. And in this case, Mrs. Justice O'Fallon held the test was satisfied because the interpretation of Regulation 32(2)(c) was of general public importance. And it was in the public interest to be resolved because the award of a contract without publicity or competition, she said, quote, goes to the heart of good governance. And it does seem to me, reading that judgment, that it'll be relatively easy in procurement JR cases to make a case for a cost capping order where an impecunious claimant has standing, and the case raises a question of the interpretation of procurement regulations, because almost by definition, the interpretation will be of wide application in the public interest to resolve. And to stress, this wouldn't be an issue that arises in a claim under the regulations, not least because most economic operators would have deep enough pockets, but also the cost capping rules only apply to JR. Thirdly and finally, a brief reminder that in judicial review proceedings, the usual rules of disclosure don't apply. And that's because defendants, and for that matter, interested parties, such as contractors, in JR proceedings, are under a duty of candour, which requires the defendant not to act like a defendant in commercial cases, but to assist the court, providing a full explanation of the relevant facts and reasons for the decision under challenge. Cards on the table approach is how it's been described. And that includes professional obligations on legal representatives acting for defendants and interested parties. And as a result of all of that, disclosure is a last resort in JR, usually after the duty of candour exercise has been undertaken and the claimant thinks further information needs to be provided or the material provided has been unduly redacted. This arose in the third set of the Good Law Project proceedings, the challenge to the various PPE contracts, the main hearing of which concluded today. There's two judgments recently of Mr. Justice O'Fallon on this issue. Neither of them raised any of points of principle, but I think they're a worthy read for anybody practicing procurement who might be facing a JR as a statement of the principles of duty of candour in the context of public procurement. And again, with the recent pushback towards a more liberal approach to standing in procurement JRs, those principles may now be of greater importance to procurement lawyers than they were before. That's all from me. Over to you, David.
Charlie, thank you. A lightning tour in both senses, in that it was very fast and very illuminating. Good pun on lightning there, I thought. I might actually say that again. No, not quite. But you omitted to mention, Charlie, which I'm deeply wounded by, your and my podcast on the subject of standing.
You already mentioned it, absolutely.
I know, but it bears another, you know.
We go into some detail on the standing issue, so yeah, absolutely.
Just before we move to Fionnuala, though, we have a question about the read across in terms of policy, and the question whether the challenge to non-compliance with policy in the Good Law Project case might relate back to Simon's topic of the potential non-compliance with social value 10% of the scoring question. Does anybody want to chip in on that, Charlie or Simon?
Well, I suppose I should say that maybe I was then Charlie can follow, but I was thinking, of course, of the enforceability by an economic operator under the regs of this government policy. But I think you need to layer in also the possibility of a judicial review being brought either by a pressure group or indeed by an economic operator. And an economic operator may struggle more than a pressure group in terms of standing. It'd be interesting to see what Charlie thought about that. But it is a fairly clear policy with this sort of particular footnote in the guidance, which says that where there's a good reason to depart from it, that then the authority has to set that out. But there must be a potential for judicial review if a government department is not following this policy. Charlie, what do you think?
I agree. I mean, it may actually be an area where judicial review potentially at least has a broader range of grounds than under the procurement regulations, because failure to apply a policy in principle is a ground for judicial review in public law. It does sort of go back to that question that nobody really likes to address head on, which is procurement really public law in the first place? But on the assumption that it is, which is the received wisdom, then I think it must be a potential ground for judicial review in this context.
It's not hard, is it, to imagine a scenario where a contract is, for example, going to have a particular impact on a particular area, either geographical or social, and some representative body of that area says, well, writes to the minister and says, we hope you're going to give this much weighting to this sort of this element of tenders, and then feels that it hasn't been done. They might seek to challenge it. Sarah, do you want to chip in on this?
No, well, I mean, I agree. On the basis of the sort of findings that we've been looking at in the Good Law Project, yes, that could be a potential challenge.
Right. Oh, good. More challenges. Thank you both, Sarah and Charlie, and thank you, Simon, for chipping in on that question. So now for our last talk, we turn to Fionnuala. Excuse me. Oof. Who is going to talk about the issues that arise when you have an interested party involved in procurement litigation, usually, I suppose, or possibly always the successful tenderer whose success is being imperiled. Fionnuala.
Thank you, David, and thank you everybody else for very interesting talks this evening. Yes, I would like to talk about interested parties, and they are often, but not always, the successful bidder. But let's just start with the successful bidder for my first couple of knotty problems. So you or your client get the joyous news that they have won the competition, and they start to mobilize for contract award and performance. And then the rain falls on that parade when a challenge arrives, and the contracting authority, they often tend not to be terribly informative in those situations, but the contracting authority eventually says, yes, there is a challenge, and you start to see what the basis of that challenge is because you get to see the pleadings. And then you're champing at the bit to assist them in their application to lift the automatic suspension. only not one doesn't arrive. And let's say that you're the challenger is the incumbent, and your client's very worried that it's terribly easy for the contracting authority to simply extend with the incumbent and leave your client high and dry with this marvelous, lucrative and very attractive contract dangling. And so they come to you and they say, can they make an application to lift the automatic suspension? To which you respond in a slightly panicked tone, gosh, that's a very interesting question. That did happen in a case where I was acting for a challenger, and the winning bidder threatened to do just that. In the end, the contracting authority did make the application, so the question didn't arise. I, on behalf of the challenger, was slightly outraged and pointed this out to the judge, and he rather quashingly said to me, well, such a course would of course be breaking new ground, but we never got there. Now, Simon raised it with me again earlier, and which is why I'm talking to you about it. What do I think would happen? How do I think it would work? I don't have a sure answer because I have no experience of it happening. I don't think it has. But here are some of my thoughts about it. First of all, if you look at the regulations, they don't actually suggest that only a contracting authority can make such an application. But I think, because I'm a very practical lawyer, the first thing I would say to my clients is, what do you think the contracting authority might make of it? Is it something that your future contracting partner would welcome? Because if they haven't made the application themselves already, there might be really good reasons why they don't. And of course, contracting authorities don't apply to lift for many reasons, but particularly they might be worried about the merits, or they may decide that they don't want to pay twice. They want to actually let the litigation play out and see who wins. So that they don't end up in the position of letting the contract and then finding they have to pay damages at the end. Anyway, there may be many reasons, but practically speaking, I think it's unlikely to be an endearing tactic for an interested party to adopt. And also it's worth remembering that, of course, you can't force the contracting authority to contract with you. So even if you were to obtain such an order, it might prove to be worthless or worth very little, and more of that in a moment. So anyway, the client is impervious to your practical advice and says, I'm very keen to give it a try. So let's have a look at how that might play out and how you might put together your evidence. Of course, the tests are, is there a serious issue to be tried, which is not a high bar, and you can imagine that you could do something with that. But then the questions are damages an adequate remedy, and most importantly, where does the balance of convenience lie? The evidence of the contracting authority about how important, how urgent, how essential it is for the public good, for innovation, for whatever it might be, one can think of all the different factors that there have been in the cases over the years, how important it is to let these contracts is really pretty central to the court's exercise of discretion. And what you're asking the court to do is to overturn what was the primary remedy under the regulations. It was intended to be the primary remedy under the regulations, which is to put a pause and to let the court decide to get the right answer and not to run the risk of having to pay twice. And it's easy to forget that because, of course, on the numbers, more of these applications to lift succeed than don't. But that is what you are asking the court to do. And I think that will be extremely difficult to do if you don't have the contracting authority leading the charge. Just putting myself in the judge's position for a moment, I would be asking where the contracting authority was and why they weren't in my court and why they weren't telling me how important it is that they let this contract. And I would be most unlikely, I think, to lift the automatic suspension if the contracting authority wasn't asking for it, because I think I'd be quite suspicious about what they felt about the merits of their case and why it was I couldn't then allow the suspension to remain in place and to try the case and then decide at the end. I'd also be reluctant to engage the court's time in granting an order that wasn't being sought by the contracting authority because it could be an empty order. And again, courts won't grant remedies that they think are effectively empty. So in my view, it would be unlikely to be a happy application or outcome, but very happy to debate it with others afterwards. And if I'm wrong, of course, then you can tell me why, and I'll be making the application next week. So the next point that I come to is the question of could my client make an application for a cross undertaking in damages, even if the contracting authority isn't making an application to lift? Of course, if the contracting authority is making an application to lift, interested parties do ask for their own costs and to be taken into account in the amount of any undertaking in damages which are sought from the applicant. So in a way, why shouldn't that be a matter for consideration if the litigation is proceeding without an application? So, and you can see the attractions, because the winning bid has been held dangling. Maybe they've got a long period of validity for price and they're hanging around. Who knows how things are going to turn out? So the first point to make is that I don't think that that fits neatly into the regulations at all. The ability to require or impose undertakings is conferred in the context of the court's consideration of an application to lift. So I think you'd be left with the inherent jurisdiction. But I think I've struggled really to think of a set of facts where it might eventuate. I'm not saying that they aren't, because there are always exceptional cases. But I think that the court will regard such an application with suspicion for all the reasons I've set out above in relation to the application to lift. But this was a question, again, posed to me by Simon. So Simon, I'm very happy to engage in lively debate with you at the very end. And you can tell me where I'm wrong about that as well. But
just by single combat, I think that might be more entertaining. But go on.
Arm wrestling, we can't do that on Zoom. And this brings me to my third and final point, which you'll all be relieved about given the time. I wanted to talk about confidentiality in the context of interested parties. So no sooner have you delivered all this good news and unhappy advice to your client, but the challenger makes an application for early disclosure and seeks a copy of your client's bid. They're fierce competitors, it's a tight market, and your client is appalled for reasons we can all readily understand. They're even more appalled when you tell them that the court might well, indeed probably will grant such an application later, if not at an early stage when full disclosure is given later. And then you talk to them about confidentiality rings and the protection that they offer. And of course, one has to say that judges, the courts, place great faith in confidentiality rings to enable the balance to be held between the protection of confidential information and the need for a litigant to be able to make its case. And I'm sure our experience of this is that by and large, they're right. Professionals involved take the matter extremely seriously, and I don't know of any intentional breach of such a ring, and any inadvertent breaches are dealt with very professionally by all concerned, in my experience. The most ferocious confidentiality situation and ring that I've come across is in the rail franchising litigation, where I acted for the Department for Transport. There, the challenges came from disqualified train operating companies and involved disclosure being given into confidentiality rings to excluded bidders, initially while the competitions were ongoing. So as the contracting authority, you were facing a live competitions, giving and having to give disclosure to people who were no longer in the bid while still running the competition. It was uniquely, exquisitely unpleasant. That was also a small, tight, fiercely competitive market and subject to competition law constraints. And effectively what it meant was that the excluded bidders, or at least the representatives in their confidentiality rings, would know more about what was going on in the competitions than those who were still in the running. As I told the judge, in a high-pitched tone that probably only dogs could hear. Anyway, I don't know, perhaps he didn't hear it because orders were made, not for the bids to be disclosed at that stage, but for evaluation materials, which of course refer to all bidders and give an insight into the competition that those who were still in it couldn't have. But it worked. It worked, and as I say, I knew of no advert breaches of the ring. In that case, there were initially 4 separate confidentiality rings to accommodate each claim, with various different interested parties intersecting with each ring, which is my point earlier, David, about it's not always the interested is the winning bidder. You might have still competent bidders who are in the ring, and then there were other parties who were interested because they were regulators and so forth. So we had a cast of many thousands. The 4 rings were eventually replaced with a super ring that everybody was admitted to, so as to make it possible to run the trial. In the interest of full disclosure to one's client, I have to repeat at this stage something that Sarah spoke about in a surgery earlier this year. And if it's recorded, it's well worth listening to. She talked about her experiences just having finished a trial, is that the closer things get to trial, the less the judge will tolerate anything other than the most justifiable claims for confidentiality. By the time of trial, the interest of open justice and the need for litigants to be able to make their case trump many claims to confidentiality, and particularly the ones about which you're always very nervous in the first place. That's certainly not to say that genuinely confidential information is thrown open to the public gaze. It's not. But my advice to interested parties, and indeed everybody, is that you should be very clear about the reasons to assert confidentiality, so that all the way through the case, your ethos with the judge remains high, so that by the time you get to trial, if you say it's confidential, then they will take you seriously and they will protect your client's information. That's it from me. Unless Simon wants to engage with me on, but we're very close to the end. Sorry.
We are rather close to the end. Sadly, no time for an arm wrestle, but I think we should certainly schedule that in for our next surgery. So thank you, Sarah, Simon, Charlie, and Fionnuala for four very stimulating and clear talks, which actually kept to time. I'm going to have to go and have a lie down to get over the shock of that. I hope everybody watching has enjoyed this and profited from it. Don't forget that it's recorded, so if there are bits that you want to go back to, you can just go to our website. And don't forget our lovely podcasts as well. I'm not going to plug, oh, I really won't plug that one, but yes, do have a listen to the podcasts available from all good and probably bad podcast providers. Thank you all very much for attending and have a lovely evening. With that, goodbye.
Goodbye. Thank you, David.